Um, Hi, everyone. It was a bit low. I'm not that short. So I'm Katie. I talk really loud, so maybe I'll stand back here a little bit. So we're going to talk about the planning process in general first, because I would guess that a lot of you here probably don't know what planning is or why we have to plan. So we're going to talk about that, and then we'll get into some of the specifics here. So basically, as I said, we're going to talk about why we do planning, hierarchy of planning in Ontario, the planning process in Severn specifically, what is an on-farm diversified use, which is the term the province has assigned to agritourism and that type of activity. Hopefully then we're going to have lunch, and then we'll talk about how to gain approvals in Severn. If I can get through this really fast, we'll talk about all that before lunch. So essentially, why do we plan? So just to back up and talk about land use planning in Ontario in general. So I am a registered professional planner. We have multiple planners at the township. The province of Ontario essentially mandates that we have to do planning. It is one of the government roles assigned to municipalities. So the reasons we plan is for, just a handful of them on the screen here: environmental protection, avoidance of urban sprawl, population growth management, efficient use of resources. So that would be resources like water and sewer, but also resources like aggregate farmland, protection of that, reduced impacts of transportation, promotion of compatible uses, public health and safety consideration, and good neighbor relations. So Ontario's land use planning legislation, so the acts passed by the province, they aim to cover all of these items, many more, and that becomes the foundation of how development or applications to do something is evaluated within the province of Ontario. So really quick story, I love to travel a lot. And I was down in a country in the Caribbean, and I was trying to explain what planning is and why we plan. And the guy just didn't get it. He was like, I'd love to have a gas station next door to my house. That would be so convenient. So it's just a way that we, kind of dating back to the British system, organize land uses, try to avoid neighbor conflict, and also try to efficiently use the resources that are here in our backyard. So this is kind of how the legislation is set up. So the Ontario Planning Act is the main piece of legislation passed by the province. With under that is any provincial plans or policies that are passed by the province as well. And then under that is the South Georgian Bay Lake Simcoe Protection Plan, which is passed under the Clean Water Act, followed by the County of Simcoe official plan, the Township of Severn official plan, the Township zoning bylaw, the Township site plan control bylaw, and then any other municipal bylaws, building codes, all that kind of thing. So it kind of funnels down. If you think about it, each thing at the bottom has to be in compliance with something at the top. And any decisions the Township Council makes has to conform with all of these items. If it's a township bylaw, they might be able to change that bylaw, but it would still have to conform to everything above it. So just to talk about this a little bit more, so the Planning Act is the main provincial legislation. It provides the framework for all the land use planning system in Ontario. It establishes the County of Simcoe's planning authority, which is our upper tier here, and that is subject to change. Perhaps, if you've heard about Peel Region's changes, that may happen in Simcoe County. They're not 100% sure yet, but it does establish the basis for that. It requires the township to have an official plan and to have a zoning bylaw, and the Act provides for the process that integrates the interests of the province, the county, the township into all of the decision-making processes that council does. So just for example, the Act identifies the process for most land use planning decisions to happen in an open format. So it happens at a council meeting. There's a public meeting before peers and before neighbors if they come. It also establishes complete application requirements, which we'll talk about later. It establishes the process to appeal to the Ontario Land Tribunal. It also establishes timelines for decisions, notice of application, advertising for public meetings, all that kind of thing is within the Planning Act. Next, under the Planning Act is applicable provincial plans and policies. The current one for us in the Township of Severn is the Provincial Planning Statement, or the PPS. This document specifically sets out the initiatives of the province. So things the province is interested about in protecting or categorizing at a provincial level. So it protects farmland, it protects environmentally sensitive lands, it protects resources and allows for the extraction of aggregate resources, and also hazard lands, which could be a human hazard or an environmental hazard from a safety perspective. And it's basically the original roadmap to how you accommodate growth and housing supply. So where you can grow, how you can grow. And then all the official plans and decisions on development applications must comply and conform with provincial plans. There used to be a provincial plan here called the Growth Plan. It's not in effect anymore, so we in Severn just have the PPS. Other places, even Oro-Medani, for example, has the Lake Simcoe Protection Plan. Down, they have the Greenbelt Plan, more in the southern end of the province, as well as the Oak Ranges Moraine Plan. So we don't have those here, but those are other examples. So next is the South Georgian Bay Lake Simcoe Source Protection Plan, which is under the Clean Water Act. It is tied into the Planning Act. Some of you may be familiar with this because sometimes this does fall into farmers' territory, and they look at things like where you're storing your manure and all of that. Essentially, the Clean Water Act, ever since the Walkerton disaster, most of you will probably remember, it essentially mandates the township has to protect the municipal drinking supply. So it doesn't mandate private wells, it doesn't mandate private water systems, but it does mandate the municipal system. So the Township Council has appointed SSEA, Severn Sound Environmental Association, to be the risk management official and risk management inspector. Some of our neighboring municipalities use those as well. And the policies of this source protection plan are implemented through the township's official plan and the township zoning bylaw. So next in the kind of hierarchy working down the list, we have the County of Simcoe and the Township of Severn official plans. Both of these official plans set policy objectives for the county and the township specifically, but they have to be consistent and conform to the provincial plans. So as much as council might want to allow certain things, they can only do that if it meets the provincial document because we're working down that hierarchy. So the official plan sets direction on where land use will occur and when. So we plan for 30 years out for where a settlement area might expand for. We also indicate areas for industry, for retail, for tourism uses, farming, all that kind of thing. So a settlement area is our communities. We're in the settlement area of Coldwater right now. Part of the exercise is identifying, where services will become available in Coldwater and where Coldwater may grow. That's a planning exercise. The official plan identifies the water and sewer, arterial roads, environmental areas, all that kind of thing. And it establishes local health and safety policies as well. So the document most people are familiar with because it comes into daily lives when people apply for building permits, all that kind of thing, is the zoning bylaw. So the zoning bylaw is the most practical document. It implements the objectives of the official plan, and it's the legal document that allows for land use to be managed. So it's the one that sets out conflicting land uses. So it says where an industry is going to go versus where a house is going to go. It says setbacks to lot lines, maximum lot coverage, height of buildings, parking standards, and then the use goes along with that. It's also listed within the Ontario Building Code under other applicable law. So basically, if you apply for a building permit and you don't meet the zoning bylaw, we will not issue your building permit because the building code refers to this document and says you have to meet this document. So the last thing in the planning hierarchy that I'm going to talk about is a site plan control bylaw. So site plan control bylaws are section 41 of the Planning Act. Again, something mandated by the province. The township has a bylaw which speaks to this. It links back to the township's official plan, and it establishes which uses would require a site plan agreement. So typically the uses would be commercial, industrial, institutional, and any large-scale housing development, so if it's more than 10 units. The intent of this site plan agreement, so it's a legal agreement registered on title to your property, it's to ensure the orderly, safe, accessible, and functional development of the site. It implements the policies of the official plan and the zoning bylaw, and it references a final set of approved drawings, reports, and plans, such as a lot grading plan, environmental impact assessment, dark sky lighting requirements, and servicing. And as I said, it's registered on title, so it binds the current owner of the property and any future owners. The drawings all have to adhere to the engineering standards, industry best practices, and it provides for how the terms of the agreement will come into play. So a certain amount of time you may have to implement those things. And again, it's listed under other applicable law of the Ontario Building Code. So if your property requires a site plan agreement and you don't have a site plan agreement, we cannot issue you a building permit. If you apply for a building permit and you have a site plan agreement on your property registered on title, then again, we can't issue a building permit unless it complies with that site plan agreement. So that's all the legislation from the province establishing how this hierarchy works. So again, it all falls down. So the Planning Act establishes how all of this fits together, and then each of the documents feeds into that. The documents at the bottom must conform to the documents at the top. So sometimes you can change how these documents apply to your property if that proposed change goes up the ladder and conforms to all of those other things. So if you want to change one of the township bylaws, or township council wants to change one of the township bylaws, they can only make that change if it conforms with everything going back up the screen. So it's really a top-down approach, and the province sets all of these parameters. So for example, you can change the county's official plan, you can change the township's official plan, you can change the zoning bylaw, you can even change the source water protection plan, as long as what the change you're proposing will line up with all the items above it on that chart. So in terms of all the applications we deal with in the planning department, there's an official plan amendment to change the official plan, a zoning bylaw amendment to change the zoning bylaw, a minor variance also used to change the zoning bylaw, so you could think about that as a minor change. So you could change things like adding a land use, taking away a land use, establishing a setback, reducing a setback, increasing lot coverage, setting parking restrictions, all that kind of thing. Those are all done through those applications, the OPA, the zoning bylaw amendment, the minor variance. To create a new parcel of land, that's either done through a draft plan of subdivision or through a draft plan of condominium. Those are for large developments, obviously. A consent is a one-off lot creation or a lot line adjustment. That's done through a consent application process. Essentially, the Planning Act prescribes what is required to submit with those applications. So again, it's not the township saying you need X, Y, and Z. The Provincial Planning Act says what you have to submit in support of those applications. The Planning Act also says when and how that information would be provided to the public, when and how a public meeting would be advertised, and also how that public meeting would be held. So that is all set out by the provincial government. So if you ever want to apply for any of these applications, the first step would be to talk to someone in the township's planning department. So this whole on-farm diversified use. So that's the term we use in land use planning, and it comes from the province's provincial planning statement. The current PPS is from 2024, so it's only from last year. But even before that, this term was established. And it essentially dictates what can be done at the provincial level on prime agricultural lands within prime agricultural areas, and then it identifies this on-farm diversified use definition. So the definition states a use that is secondary to the principal agricultural use of the property, limited in area. On-farm diversified use include, but is not limited to, home occupation, home industry, agritourism, uses that produce value-added agricultural products, electrical generation facilities and transmission systems, and energy storage systems. So what we see most at the Township of Severn is those home industries, those home occupations, and as well as the agritourism. We have had a few inquiries about the energy stuff, but that's not primarily what we talk about when we are talking about on-farm diversified use. And obviously the session today is focused very heavily on that value-added product and also the agritourism use. So back when they first proposed this defined term, the provincial government released a guidance document, it was in 2016, and it's called Guidelines on Permitted Uses in Ontario's Prime Agricultural Area. It specifically speaks to agriculture, agriculture-related, and on-farm diversified use. So those three kind of defined terms I was just speaking about. And it also establishes what limited non-agricultural uses can occur in these prime agricultural areas. And its intent is to mitigate the impacts from new or expanding non-agricultural uses. So within this document, it essentially highlights the three different areas. So when you have agricultural land in Ontario, you can have an agricultural use, you can have an agricultural related use, or you can have an on-farm diversified use. So there's just a few kind of guidance points there in this little table. It is available in full in the document, but your agricultural uses would be things like having livestock, having crops, that traditional agricultural use. The agricultural related is a little bit more into the industry. And then the on-farm diversified use is that whole bringing people onto your property for the agritourism or something like that. So this chart is, it's table 1 within this document, and at the end there will be links to all these documents. So when Becky sends you the slides, you can go in and take a look if you want. So just to get into the on-farm diversified part a bit, since that's what we're really here to talk about, these are some great examples that are basically listed within that document. So the first one you can see there is that's actually someone making cheese. If we look at that very first, I don't know, picture, I guess, of the hands. So that's a value-added product, right? So they'd be using stuff from their farm, but also imported probably ingredients or ingredients from a different farm to make a product. So that would be an on-farm diversified use. The next one you can see there, a guy at his computer. That would be like a home occupation. So if you wanted to cut hair, if you wanted to be an accountant, a veterinary clinic, all those kind of things that are just occurring on the property. Maybe you're using part of your house, maybe you're using part of an outbuilding. And then same with the next one, you can see the, I don't know, lumber or pieces of wood or whatever in that picture there, same kind of thing. So maybe you're using an outbuilding and you have, you know, you're a cabinet maker, you're a machinist, you have a machine shop, something like that. So you're taking an agricultural building or you're building a new building on agricultural land and running some kind of home industry out of that. In the second row there, you can see the entrance sign. That's more the traditional agritourism uses. So they give an example, I think, of a pumpkin patch, of a hay maze, all of those kinds of tourism type uses that we've really seen pop up in the last few years. That middle one on the bottom, an antique shop, again, that small retail component that could be a value-added product, so selling some products from your business, but also perhaps local other products. And then that last one, which we've all seen a lot about with cideries and wineries and things like that, and having some kind of small cafe or restaurant or tasting room that goes along with that on-farm diversified use. So again, this is just right from that document that you can go in and check. Oh, and we still have lots of time before lunch, so we're just going for it. So how is an on-farm diversified use treated in Severn? So Severn has a brand new official plan. So it actually talks about this term, whereas our old official plan, which was like from when I was in high school, definitely did not talk about this term. So the term on-farm diversified use, it is permitted within the agricultural designation of the new official plan. So the new official plan just went to County Council, County Simcoe Council this month, February 2025, and it specifically allows for this. So it sets parameters that, again, are consistent with that provincial direction that we have to follow. So within the official plan, you can go to the mapping, you can look on the map, identify your property, and see what the designation is. This is just a little snippet on the screen of the legend from the map to see, because you may be designated greenlands or rural or something that's not agriculture. So if that was the case, then you may need an official plan amendment to do an on-farm diversified use. And again, those designations, they have to be consistent with the county's official plan. They have to be consistent with the policies of the Planning Act. So we didn't just arbitrarily map your property as something. And in reality, the township of, the former township of Aurelia or Matchedash or whoever it was, they mapped your property probably in the 1990s and you just didn't know about it. So most of that has just been carried forward. So next level down is the township zoning bylaw. It was passed by Township Council in the fall of 2010. It was the first zoning bylaw the Township of Severn ever had. Prior to that, they had all the former township zoning bylaws, so ones from the 1980s, the early 1990s. And again, because of the age of it, it does not specifically speak to on-farm diversified use, because as we learned earlier, that's basically something that came about in 2016. So although some of the uses might fit into some of these categories, it doesn't specifically permit it anywhere. So for example, a veterinary clinic, it is permitted within our agricultural and rural designations. That would be considered an on-farm diversified use. An equestrian facility, depending on what you're proposing, that may be an on-farm diversified use. That is permitted in certain zones without a rezoning or a zoning bylaw amendment. So some of them just happen to fall into these categories, but most of them that people are proposing don't fall into the zoning bylaw, which means you need an amendment from the zoning bylaw. So essentially how most of them have worked in the township is that you propose a zoning bylaw amendment application, you propose a site plan control application, and then a building permit application. So all of the proposals are unique. We haven't had two applications that are the same. We have had two applications that try to do a similar use, but really every property, every application is unique. And I think going back to some of the presentations this morning, that's why some of these businesses are really successful, is because they're offering a unique experience. So even when we do a new zoning bylaw, I'm not sure we'll be able to capture all the on-farm diversified uses within that new zoning bylaw, just because they are all so unique. So typically this would be the process to do an on-farm diversified use in Severn. This is a really complicated slide I'm not going to get too much into. It was actually a slide we did for council, but essentially it establishes what you can do for a pre-consultation. So before you submit an application, before you go down that formal process, you can submit a pre-consultation, which means you pay a bit of money, you have a meeting with all of the township staff that would be involved in reviewing the application, perhaps our consultants, and it takes a few weeks. A pre-consultation, we have a stage one, which is a simple meeting, a simple, a very brief business proposal, site plan, whatever you have. But we also have a stage two, which is available, and that would be more if you already had a lot grading plan or you already had some studies or reports to back up your submission. So this is the process for an official plan amendment or a zoning bylaw amendment. So I just wanted to throw this up here because there's a lot of steps involved with this process. Some of them are township steps, some of them are circulating to people like our consulting engineer, because we don't have an engineer on staff, circulating to Ministry of Transportation, for example. All of that, those players have to comment, they have to be involved, and it can take some time. And again, a very similar process for site plans and how we circulate that through, how it works through the process. So as you can see by those slides, it's complicated. It really is. I don't know how to put it another way. It is complicated, and that's because of all of those documents we talked about earlier. So it's because the province is saying you have to be consistent with the Planning Act, you have to meet the county's official plan, you have to meet the township's official plan, you have to meet these guidelines, you have to meet the PPS, and lastly, you have to meet the Ontario Building Code. So we have to review all of that information and make sure that your proposal is meeting all of those things. So most people, that's the number one complaint we hear, is that it's expensive and it takes a long time. So in order to make those processes go faster, First of all, right when you come up with the idea, you should talk to township staff, and we're going to tell you if this is an idea that you can go forward with and what's going to be involved to do this idea. Because you don't want to get years down the road and then we basically come and shut your business down. Because we're trying not to do that, and that's why we're here having this presentation today, is so that when you have an idea or when you think you know what you want to do, come and talk to us first. There's usually someone at the office in the planning department. You can email us, you can call us, whatever you want to do. Once you do that, if we tell you, this is a great idea, you need a zoning bylaw amendment, you need a site plan agreement, whatever it may be, then you should hire a consultant. And you should hire the right consultant. So it might be that you need a professional engineer, you need a registered professional planner, sorry about that. It depends on the project, and we'll advise you on who you need to hire. And then you want to submit everything together at one time in digital and paper copy. Submitting things piecemeal, which we see a lot on small projects because people are excited and they get their lock rating plan one day and they submit it, and then 3 days later they get their environmental study and they submit that. That's not really helpful to us because we're waiting to review everything as a package anyway, especially if we don't know if you didn't tell us you're going to submit something and then 2 weeks later you submit something out at the blue. People may have already started to review what you've already submitted, and now it's just kind of throw a loop in that process. So just make sure you have your submissions together. Make sure whatever consultant you hire or whoever is project managing it is really making sure that they're bundling up these complete submissions so that you don't get a couple weeks down the road and we reach out to you and say, hey, where's your lock rating plan? You never submitted that. So just make sure that your consultant or whoever you hire to project manage is on top of the submission, and that it's complete, it's organized, it's legible, all that kind of thing. And then the next question you're going to ask me is, why do I have to hire that consultant? So township staff, in my role, in our building people's role, we cannot fill out the application form for you. We can't tell you how to do the drawing. We can't draw it for you. My role as a registered professional planner is that I have to work in the public interest, which in this case is the entire public interest of the township. So, for example, the reason we don't have a professional engineer on staff is because we're trying to keep your taxes low. So if we were to have enough staff, just on staff, to help every single individual with their applications, the entire tax base would pay for that. So the whole model in Ontario, if you've heard of development charges, is that development pays for development. So if you're proposing a development, even if it's a small scale development, then you have to pay for your consultants to pitch that to us, because we are trying to then objectively review your application on the best interests of the entire township, the best interests of the tax base of the township, and then we're giving that professional advice to council for them to make a decision. So really, you need someone, it depends what you're proposing, but you'll need a professional engineer, for example. You might need an architect, you might need a planner. It just depends on the application that you're proposing. So the Planning Act, as well as the township's official plan, because our official plan has to be in conformity with the Planning Act, sets out a list of complete application requirements that have to be met for you to submit something. So for example, if you want to add an on-farm diversified use and you need a zoning bylaw amendment, you need to submit the application to us. And although we created the form using this giant list I'm about to show you that the province established. So this is Schedule 1 of Ontario Regulation 54506. And as you can see right there, or you probably can't unless you have really good eyesight, number 4 says that you need to identify the designation of your property under the official plan and an explanation of how your application conforms to the official plan. So, some of you may be able to do that for yourself. You might be able to read the County of Simcoe's official plan and the Township of Severn's official plan and give an explanation of how your application meets those two policy documents. But if I wasn't a planner, I probably could not do that. So that's just one example. These are all of the things that need to be included in a zoning bylaw amendment application, and this is why most people need to hire a consultant, because most people cannot answer these questions for themselves. There's 32 items. The last 3 I have underlined there all are similar to the official plan question, but pertain to those provincial plans and documents that I spoke about earlier. So you would essentially need to read all of those plans and then give us, information on how your proposal is consistent with all those plans. So, given that example, I think you can probably see why this is complicated, and we at the Township of Severn did not invent this system, right? This is what the province has told us we have to do, and we are just trying to orchestrate that. So, the other end of that also is that sometimes we at the township need to hire a consultant to review what you have submitted. Again, the township doesn't have a professional engineer on staff. We don't have a hydrogeologist on staff. We don't have an architect on staff. Because if we had those people on staff, you would pay a lot more in property taxes because we would have to pay those people. So the developer ends up having to pay that as well. And again, it depends on the application. So this slide is stolen from a council presentation I did before. Most people applying for an on-farm diversified use don't need a hydrogeologist. That's somebody who studies groundwater. So unless you're trying to take a lot of groundwater, you probably don't need that consultant, but that's just for an example because you will need a professional engineer to do lock rating. If you're having a building, which my colleagues will talk about later, you might need an architect, professionals like that.
Sorry, I have a quick question.
Sure. Great question. So on this slide here, if you have your zoning already in place or council's passed your zoning bylaw amendment, the only thing then you need is you may need a site plan control agreement. So if you're putting up a new building, you might need a site plan control agreement. If you're converting a building, you might need a site plan control agreement. It's about how you're funneling those people onto your property. Things like the parking, the washrooms, the accessibility, all of those things are reviewed during the site plan process. So it really depends on the proposal. We did do an on-farm diversified use recently where they only use a limited amount of outside space. They did not need a site plan agreement, and they don't need a building permit because they're not having a building, but they did need a zoning bylaw amendment. So it just depends on the application. It's really hard to kind of answer that question without knowing specifics, and I'll give you my card because we're not going to get into the specific today.
No, I just have one quick question.
Sure.
If you're doing all this, do you have to meet the, I forget what the acronym is, but the Ontario regulation for People with Disabilities Act or whatever?
Absolutely. So if you're charging money for someone to come to your property, you're a business, and you're no different than any other business, on the main street of Coldwater here, or that's opening in the city of Toronto. A brand new business needs to meet the AODA requirements. Yeah. So the site plan agreement is basically the last in the planning step before it gets turned over to the building and fire departments. Signing this site plan agreement means you're legally agreeing to complete all the items identified in the agreement, whether that's timing, what's illustrated on the plans. So just for an example, this is a site plan. You can see kind of the level of detail. Obviously, most of you are seated far away and you can't really see the level of detail, but it identifies things like your fire route and signage. This one has a dry hydrant for firefighting capabilities. It has 2 buildings that were converted. It has an AODA lift because it's a 2-story building, and you can't have a new 2-story commercial building unless you have a lift because you can't just rely on stairs. It identifies where the parking is. It identifies where the washrooms are. Depending on what you're proposing, you might be able to have portable washrooms. You might have to put in a permanent washroom building. You might have to put in a septic to go with your permanent washroom building. So it really just depends on the proposal. But this site plan basically identifies everything that needs to legally be there when you then open your business. So when you sign the site plan agreement, you're agreeing that you're going to put up these signs. You're agreeing you're going to have gravel where this plan says you have gravel versus where it says you have grass. So I think a lot of people, even contractors who do this all the time for a living, kind of forget that when they're making these plans or when their clients are making these plans, it actually means at the end of the day, your property has to look like this. So if you need to be involved with your consultants, because your consultants are going to do things like draw up a parking lot, and at the end of the day, you're going to have to create that parking lot. You're going to have to figure out how to delineate those parking spots, and you're going to have to execute that and then maintain that. So if they're saying that all the cars are going to park in one location and you think they should park in a different location, then you need to convey that to your consultants, because we're not going to sign off and give you your deposit money back unless your property looks exactly like what you told us it would look like. So if you want to change it halfway through, or a few years down the road, you want to add a new building or you want to add more parking, then you need to go through a process to change what's already been approved. So it's really important that although you hire a consultant, that you remain involved in what the consultant's proposing for you. Because we've had a lot of people who said, you know, I wanted the farm storage to be on the right-hand side and my consultant drew it on the left-hand side. Well, then you needed to have looked at that plan and understood that that plan is going to be implemented in real life. So this is pretty much it for me. Oh, and we're like 5 minutes early. How exciting. So when you get these slides, all of these green words are the hyperlink. So you should be able to just click on that and it'll bring you right to that document. So the on-farm diversified use guidelines that I talked about are on there. There's an OMAFRA, that is the OMAFRA guideline. Ontario Federation of Agriculture has a page on on-farm diversified use, the provincial planning statement, our official plan, our zoning bylaw. I also included on there the City of Aurelia's consultant list. We're not allowed to recommend consultants just because, you know, it's a fair world out there. But what I can tell people is that you can go back and look on our agendas and our council agendas and look for similar proposals to what you're proposing, because that may be an opportunity for then you to try and use those same consultants, especially if it's a similar proposal, then they've already done some of that work that you could probably benefit from. So although we can't recommend anyone, I can give you that tip that you can go back on our council agendas. All of these applications for zoning bylaw amendments go to what's called Planning and Development Committee, which is the body of council that holds the public meeting. Because when you apply for a zoning bylaw amendment, there is a circulation to your neighbors. So if your neighbors hate you and think you're going to make a lot of noise and a lot of traffic, you should probably try and work that out with your neighbor before you submit something to us. And your consultant, if they're a good consultant, will tell you that as well, because they're going to get a notification in the mail. We're going to put up a sign on your property, and then there's going to be a public meeting about your application. And people love to come to public meetings and just complain about their neighbors, even if it has nothing to do with the application at hand. So there's another tip for you. But just something to be aware of. So again, if you have any questions, if you have an idea, the first step is just to reach out to the planning department. There's 4 planners of the township. You know, one of us can talk to you on the phone. We can have a meeting in person. Sometimes we'll go to your site, whatever kind of works. And I think that's it. Oh, I did include some random frequently asked planning questions just here at the back of the slides, just in case you want some extra reading later, so I don't have to bore you now. So, any questions? Yes, Michelle?
Is anyone going to talk about the cost of this? Because the township is encouraging us all to do this. And when we look into it, it's not an affordable option to rezone and to go through the permits. And my second part of that question is, what if you have that neighbor?
So the first one, no, we're not going to talk about cost, because the cost really varies depending what you're doing. So the planning cost, like hiring a consulting planner, is pretty universal, I've heard. But then the other costs, such as if you need an engineer, if you need an architect, depending on what's happening on your property, if you need a dry hydrant as a water source, those are all costs that are very specific to your project. So it's really hard for us to talk about that. But I think someone later is maybe talking about potential funding opportunities, yes. So I guess that I'll touch on it a little bit. The second part, if you do have that neighbor, what we always tell people is just try your best. And most of the time, council and Councillor Brandon can attest to that, most of the time council can see through if it's just a neighbor conflict or if it's a legitimate concern. For example, some of our noisier venues, we've had them have to do a noise study to say, look, this expert, there are noise experts, this noise expert said that this sound is not going to travel to your property. So even though you don't like these people, sorry about your luck, the sound level will be, equivalent to your cow mooing, so there's not really somewhere you can complain about that. So we do try, and that's part of all the documents you have to submit, is to try to mitigate that and get out ahead of that. So we do have it at public meetings all the time where neighbors kind of just want to complain about each other. But usually I think our council and our staff is pretty good at seeing if there's an actual issue versus just some neighbors who don't like each other. Yep.
Follow up on that neighbor question then, if we're seeing through it as just a neighbor conflict, that still can be resolved in your favor?
Correct, yeah. So if it is very clear to us that it's just a neighbor conflict, it's probably not going to affect your application. What we have found, though, is that people respond better if you as the neighbor go and tell them you're applying for something, rather than they get this weird legal looking document in the mail that says you're doing something. So even if your neighbor doesn't like you, typically in my experience, they appreciate you showing up or calling or emailing them or Facebook messaging them or however you can get a hold of them to tell them that you're applying for this ahead of time rather than getting the notice from the township in the mail. So it's just best efforts, but yeah, certainly we've had neighbors who don't like each other and the person still gets approval. Anyone else?